One of the injunction applications brought before the High Court hours before the general elections was filed in the name of John Rollo. As a visually impaired citizen, Mr. Rollo has been very vocal over the years about the lack of provisions in our elections process, which protects his constitutional right to cast his ballot in secret. The only provision made now by the Representation of the People Act is that a person can accompany a visually impaired person into the booth to assist in casting the ballot. However, for Mr. Rollo, this gave him no security as it relates solely on the honesty and integrity of the person assisting in the process. According to sources, the substantive issue is that Section 67 of the Representation of the People Act infringes upon Section 32, subsection 3 of the Constitution. Section 32, subsection 3 of the Constitution reads, "In any election of members of the House of Representatives, the vote shall be given by ballot in such a manner as not to disclose how any particular person votes." While Section 67, subsection 4 of the Representation of the People Act makes provision for a blind elector to be accompanied by a friend who is an elector in the same polling division into the voting booth and mark the ballot paper for him or her. The matter was heard before High Court Judge Justice Glasgow. Reports are that it was argued that the Parliamentary Elections Office must provide an avenue to vote without a blind person having to disclose who they vote for. It is reported that the claimants were outraged over the court's decision and plans to appeal. Another application was brought forward by the political parties Power and Grenada Empowerment Movement, along with the Independent Caucus for Constitution Reform. Political leader of Power, Andrea Rapier, says the parties reviewed the electoral process for 2022 since elections were called and put forward 12 violations in their appeal to the court.
The Constitution in Section 32 requires that the constituency returns a candidate, which means that the candidate must reside in the constituency in which he runs. Now, when I say that, does something come to mind? Of course, because we know that there are candidates who are living in one constituency and running for another. There's also a right to register to vote clause as well, and that is in the Representation of the People's Act, Section 5, 6, and 21. Anyone that is qualified to vote has the right to register to vote, and that right was taken away from many of our citizens this time.
Ms. Rapier says the judge did not hear the substantive matters, but rather asked the parties to withdraw due to them not satisfying a procedure of the court.
So on one of our affidavits, there was a failure to, our failure, our lack of even knowing, but there's a certain statement that must be phrased in the beginning. And so the defense jumped on that saying, hey, judge, look, this isn't within procedural standards, so we really shouldn't go any further. We should just dismiss it. And it ultimately came down to, you have meat in your case, but if I listen to your case and place a judgment, the defense will look for you, the defense will appeal. And if it goes to a higher court, they're looking at how I myself have ignored the procedural standards to allow this case to be heard. However, it was withdraw the case or I dismiss it and charge you. And it was 3 of us as partners there. And the conclusion was that we will withdraw.
Rapier says the parties will not be daunted in their quest to ensure that elections in Grenada is a free and fair process. The other matter put forward by Martin Washington Edwards was also dismissed. Cherry and Blackman Stephen, GBN News.